Court is calling 2019 CR 8713 State versus Jonathan Vargas. Can I have parties approach and announce for the record?
Opinion for the state of Texas.
Morning.
John Foley, Your Honor, on behalf of Mr. Vargas.
And are you Mr. Vargas?
Yes, Your Honor.
All right, are you all ready to proceed?
You're ready to play.
Okay, let me pull up the document. All right, what are the results on the UA?
Came back positive for marijuana.
Okay. And state, what are you requesting?
Revoke his probation, Your Honor, and since it's in the 2 years TAC,
I couldn't hear.
revoke in 2 years TAC.
Judge, we asked a court to either continue Mr. Vargas on deferred or to revoke him and give him regular probation with a jail sanction if necessary. Mr. Vargas is the sole caretaker for his child. He's a stay-at-home dad. He has a business where he mows lawns, but he does that.
I mean, it's like maybe he shouldn't be taking care of his child if he's using. I don't understand why you're coming in and testing positive with the court. And according to this, you've already been sentenced to safety. So there was, who's with your child now? All right, so we have a mom who can take care of your child. So I don't know if there's anything else I can do for you because you've been to safety. I don't know how else to help you.
I had stopped smoking prior to me turning myself in. And I know I was told that marijuana stays in your system for a while.
But no, this is not your first motion to revoke.
Correct.
And it's always a motion to revoke for use. And I just don't know what else. I don't know if there's anything else available for you.
Is there any way I could be on probation and get drug tested every week?
No, because then what's happening is you're just asking probation to do extra work. For something that you have done wrong. And you've been on probation in this court since 2019, and there just hasn't been any improvement. I just don't think probation, there's nothing else I can do. What I can tell you is you will receive credit for completion of safety. You'll get credit for that. So
Judge,
yes.
if I may, I think there has been some improvement though, in that he has been voluntarily, I think he's genuinely trying to better himself. That is, he has voluntarily been seeking treatment. He's been going to that treatment. He's successful at that treatment for his heroin addiction. He did slip when he knew he was going to be turning himself in. He I think, was nervous about it, and he smoked marijuana, but he didn't go back. He didn't, regress to go back to the heroin. And I do think he's showing some improvement in that way, Judge.
All right, this is what the court is going to do. The court is going to grant the motion, find you guilty, revoke. The court is going to sentence you to 2 years in the prison, give you credit for any time served, give you credit for any time served in inpatient treatment. And counsel, if you get with the clerks, they'll be able to tell you how much time that is.
I'm sorry, Judge.
If you talk to the clerks, they'll be able to tell you how much time he's receiving for credit for the inpatient treatment.
Okay.
There's an affirmative finding of family violence. There's to be no contact with the complainant. And I'll ask for the therapeutic community.
Judge, did you say also credit for time served or just for the?
Yes.
Oh, okay, good, thank you.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Sure.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction and because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, I can't force them to place you in the therapeutic community. You'll still have to request it, but they'll see where I've requested it. That program is designed to help you with any drug issues you may have. It doesn't increase the amount of time that you're in custody. All right? All right, good luck to you, okay? You're welcome. Court is calling 2025 CR 013749 State versus Mark Anthony Perez Vargas. Could I have parties announce?
Right up for the state.
John Sheffield for defendant. We're ready, Your Honor.
And are you Mr. Vargas?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Vargas, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah, Judge.
Mr. Vargas, did you review, well, are you all waiving the,
Is there any announcement?
let me see, just one second. Yes,
Judge, we'll waive the meter and a half and proceed on just the ready to go.
any objection?
No, Your Honor.
All right, Mr. Vargas, did you review the court's admonishments and defendants waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with evading arrest, detention in a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
This is a critical moment. By entering this plea, Mr. Vargas gives up key constitutional rights like confronting witnesses. It's a huge trade-off, but it's also strategic. Plea deals can often reduce the potential maximum sentence. For viewers, always remember, understanding your rights can change the outcome drastically.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Vargas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it and sign it?
Yes, ma'am.
According to the plea bargain agreement, punishments be assessed at 2 years in the prison. This is run concurrently with 2025 PF 51672. The state will take in consideration the following cause numbers. 2025 CR 013741, 2025 CR 013740, 2025 CR 013744. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State.
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Judge, we offer to say exhibit number 1 and all of its tenants.
No objection, Your Honor.
Right, state you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just asked the court to follow the recommendation.
All right, the court will sentence you to 2 years in the prison, give you credit for any time served. This will run concurrent with 2025 PF 51672. Court will take in consideration 2025 CR 013741, 2025 CR 013740, 2025 CR 013744. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Thank you.
She's on Zoom, Your Honor.
All right, the court is calling 2025 CR 009601, State versus Kiara Henry. Can I have parties announce?
Attorney Albert Acevedo for Miss Henry.
Ms. Henry?
Yes, how are you?
All right. Good morning. So Ms. Henry is appearing by Zoom. And we're here for sentencing, correct?
Yes, Your Honor.
And she is located in another state,
She's in Michigan, Your Honor.
Michigan. All right. Are there any witnesses from either party? I believe we've discussed off record and at previous hearings, the requests from the state and the requests from the defense.
I have no witnesses, just her, Your Honor.
Okay. All right, anything you wish to say on behalf of your client?
Yes, Your Honor. Just briefly, we've gone over the PSI. Just clerical error. That's her address. It's Coyle, C-O.
Just 1 second.
Just briefly, I'd like to call my client, Judge.
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name in the record, for the record, I'm sorry.
my name is Kiera Henry.
Yes, you may proceed.
Miss Henry, you got arrested back in August of 2023, correct?
Yes,
And since that time, this offense occurred in Bear County. Did you move?
yes.
And where did you move to?
I moved from Bear County to Houston, and then I stayed there for a year, and then I moved back to Michigan, where I am now.
And when you moved to Houston, did you work?
Yes, I worked for the Houston Housing Authority for 1 year as a housing specialist.
Okay. And while you were here in Bear County, did you briefly have a job?
Yes, I worked for the United States Postal Service.
And that didn't last very long, right?
No, because I was arrested.
Okay. And were your kids living with you at the time you lived here in San Antonio and then moved to Houston and back to Michigan?
Yes, they've been with me the whole time.
Okay,
Okay.
let me ask this. What is the restitution amount that's owed?
In regards, it says 0 in regards to the report, Judge. No, there's an victim impact statement, and the victim said there was $0 restitution.
All right, so where are you working now?
I
she-
work for,
Go
I work for LR Management. I'm assistant property manager.
And does this involve her having access to people's identifying information?
The-
Social Security,
Yes.
driver's license?
It's a driver's license information at the time when she was here and pass it on to get a vehicle at Enterprise.
No. I mean, her current employment now. The current, your current employment that you have now, do you have access to people's driver's license and social security information?
Yes.
I have a problem with that. She's not going to be allowed to work there unless she informs her employer and those whose licenses and social security information that she's obtaining, she informs them of this case. Otherwise, she's not going to be allowed to work there.
Can I say one thing, Judge?
Sure.
I did not, when I got the information, I was told that it was not an actual person. I was not aware that I was using someone's identity. And that's the God's to honest truth. I did not know that it was somebody's identity. I was told it was a profile that was made up. I never knew that it was, when I found out that it was an actual, that person was the actual person, it broke me. I never would ever touch anyone's identity.
All right. So my ruling is my ruling.
Yes, ma'am.
They'll need to know. And you're going to explain to them, you thought somebody was making up profiles and creating cards.
Yes, ma'am.
But even if that were the case, it still was the wrong thing to do because somebody is holding the bag with no money being given to them.
Yes, ma'am.
All right. This is what the court is going to do.
Here's a practical insight. Employment restrictions, probation conditions, random drug testing, these aren't just bureaucratic hurdles. They're designed to prevent recidivism. And note the emphasis on transparency with her employer. One misstep could derail everything. Court systems often have this tight balance between rehabilitation and supervision.
The court is going to sentence you to 3 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, or any occupation that gives you access to others' credit card information, driver's license, or social security numbers, unless your employer is made aware of this case.
Yes, ma'am.
And you'll need to provide proof to probation that they have been made aware. So which county do you live in?
I live in Wayne County. I work in Oakland County.
All right, there's a transfer to Wayne County. And is that Michigan?
Yes.
Defendant allowed to work out of county? There's to be no restitution ordered because parties are telling me there is no restitution. No contact with Katie Boyd, and for the record, no relation to me, or Enterprise at 1128 IH 35 North, San Antonio, Texas. There's to be 100 hours of community service restitution. And I want to order the MRT. Once that's completed, the community service hours will be deemed satisfied. Taking consideration 2025 CR 009623. Field visits is available once a month for 3 months. Probation, is there anything else? Is there anything else?
Nothing further to the defense, Your Honor.
All right, is there anything else you need, Ms. Henry?
No, ma'am. Oh, I do have a question. So as far as the employment thing, my boss does know. And is this for the rest of my life or is this just while I'm in probation?
You'll have to speak to your attorney.
Okay,
Explain to you about that. All right.
okay.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal?
Yes,
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right. I'm gonna send you to a breakout room. I'm gonna move you to breakout room number 1. If you'll meet the probation officer in there, they'll go over conditions with you.
Okay, thank you.
You're welcome. And did you all tender me the dismissal? Has that already been done?
I'm not sure.
Okay. All right, thank you.
Thank
Judge.
you.
You're welcome. Just make sure you go to the breakout room. Where's Justice Sanchez?
Sanchez?
All right, and I'm taking you up because you're in custody. I know the deputies want to reduce the number of people who have to come back.
Okay.
All right, so what's happening with this case?
The state is missing his prior criminal cases, the certified copies. So I don't want to enter into any plea or anything until we have those.
State, when will you have those?
Judge, I sent an email to the county clerks. They should be back momentarily, but I've seen them take anywhere between a day or two to get certified judges.
All right, Ms. Ferguson, can you recall this in 2 weeks, please?
Ah, the paperwork hiccup. Even in serious felony cases, procedural details like certified copies can delay proceedings. It's a reminder, in the courtroom, timing and documentation are just as critical as the crime itself. Imagine the tension, months of preparation, and now we wait another 2 weeks.
Yeah, we're ready, Judge. It's just that I don't want to do anything about it.
January 27th. All right, we'll be back on January 27th.
Okay.
And if you want him brought over sooner, just let us know.
Okay. Thank you, Judge.
Kent Wells. Hello, Mr. Wells, how are you doing?
Good morning. Losing us now, we're half.
Yes.
Okay, Judge, this was a status for early termination that was sent in back in October.
Mhm.
And for some reason, a hearing was never set for it. It was set last week when Judge Angelini was here. But he said to reset it for whenever you were back in the office.
Okay.
Mr. Wells been placed on deferred adjudication for a period of 3 years back in April of 2024.
Can I see the file on Mr. Wells, please?
He has completed his community service hours, his driver safety course. He complied with all of the field visits as well as the employment restrictions, completed his anger management. He's been compliant with the no contact order and the prohibition of entering that street. He has also rendered numerous negative UAs. He's met all of the financial obligations. There was no restitution. So we didn't have any type of compliance issues or anything like that.
Mhm.
So we were asking for a consideration for early dismissal. At the time, ADA Alban was here. She opposed it. I did speak with ADA Galloway this morning. She doesn't have any opposition except for she would agree for him to be discharged in April of 2026.
Okay.
He's been on for over a year and a half. So that's where we are with everything, Judge. We're asking for the court to consider it.
All right. So let me just tell you what I'm going to do, and I'm going to explain to you why I'm going to do what I do. There are a lot of holidays that are coming up. Some holidays are distinctly San Antonio holidays. You know which one I'm talking about, right? And so I always have concerns about that. And I know when I was a defense attorney, I would be like, hey, they're going to do well. But I understand now, being a judge, I understand why judges would do certain things. So part of my thing is to protect the community. I know that you've completed everything, but I'll tell you, you've gone from the state opposing it to the state saying, hey, let's do it at the end of April. So what I'm telling you is you will not need to come back. I will grant, if you're doing well, I'll grant the motion for early termination at the end of April. and it's right around the corner.
It is.
Okay,
I'm okay with that.
all right.
The original, I think, in the notes was 2 years. The state proposed 2. My attorney agreed to 2. I agreed to 2.
And I said 3.
Okay,
Yeah.
I didn't know.
Well,
how or
see, the
where
thing,
that came from.
oh, because the state and the defense, they can make recommendations, but they're not allowed to agree on the length of probation. That's for me to decide. And I can tell you what I base it upon is whatever testimony is presented to me and what I'm reading that's in the police reports. Okay? All right, thank you.
So.
At the end of at the end of April, if there are no issues, then you will be off.
Do I come back?
No, you won't have to come back unless you just want to come back to say hi.
Wow.
You're like, I don't know about
Where's your
that.
Picture going on.
All right.
So we're good.
Thank you.